Good morning. Good morning to those in the room, in the inquiry offices, and good morning to those following these proceedings on the YouTube feed. Today is the occasion of what is planned to be the final session in relation to the inquiry's investigation in relation to the Royal Hospital for Children and Young Persons in Edinburgh. What I've done is to invite the core participants in the inquiry, if they so wish, to make final oral submissions as to what they consider to be the key issues that the evidence the inquiry has heard give rise to, and identify where they see matters of controversy and help me in determining how controversial issues should be decided. Now, I've had the benefit of written closing statements from the core participants, and I am very grateful for these. You can take it that not only have I read them, but I will continue to read them, not only in the light of the other written closing statements, but also in the light of what I'm addressed on today. So, as I've indicated, this is the opportunity, and I'm very grateful to those core participants who've taken it, to direct me towards what the core participants consider to be the key issues, the important matters, both for their clients, but also more generally in relation to the terms of reference which the inquiry must address and fulfill. Now, I have been provided with a running order, and I think I'm right in saying that the first legal representative who will address the inquiry is Ms. Forster, who is acting on behalf of IHSL. Now, I would invite Ms. Forster and instructing solicitor to come forward and to make use of the microphone.
Good morning, my lord. I'm Mark Gillespie of Vincent Masons, and I'll be leading you through the oral statement this morning.
Right. So, arrangements can change. So, Mr. Gillespie, is it?
Yes.
Right.
Yes, my lord.
Mr. Gillespie.
Good morning, my lord. This oral closing statement is made on behalf of IHSL. IHSL thanks your lordship for the opportunity to make this statement. IHSL has previously responded to the inquiry's position papers and made closing submissions following the hearings. Mindful of Direction 6 regarding the purpose of the oral statement, IHSL does not intend to repeat the written submissions, but it continues to rely upon them. Your lordship has invited core participants in Direction 6 to identify what they consider to be the key questions. This includes the identification of the principal material facts that they consider are controversial. IHSL accepts that the inquiry has identified the key questions, but given the core participants' positions, it is apparent that there are material facts that are controversial. In this closing statement, IHSL has 4 main points which highlight the principal material facts which it considers are controversial. These are the interpretation of the procurement documents, the interpretation of the project agreement, the financial pressures on IHSL when SA1 was executed in February 2019, and the letter from IHSL dated 31st of January 2019.
Sorry, Mr. Gillespie, I lost attention. 4 matters you're drawing my attention to: the interpretation of the procurement documents, interpretation of the project agreement, and then I missed number 3.
The financial pressures on IHSL when SA1 was executed in February 2019.
Financial pressures, and number 4.
And the letter from IHSL
Right.
dated 31st of January 2019. This statement will then briefly address 7 of the matters addressed in your Lordship's recent note of matters. I'll refer to NHSL as the board throughout this statement, just given how similar the NHSL acronym is to IHSL. Before addressing those points, IHSL wishes to make some general opening remarks. The Cabinet Secretary's decision to delay the opening of the new hospital, announced on the 4th of July 2019, came as a huge shock to all those involved in the project, not least to IHSL. The delay to the opening of the hospital was not an outcome that any party involved in the project wanted or expected. The project had experienced various challenges during its construction. Many of those were challenges that are often encountered on large, complex construction projects. Others were perhaps more unique to this project. Nevertheless, the parties had worked extremely hard to resolve those issues so that by February 2019, the hospital was certified as practically complete and was on course to open in July of that year. That, of course, did not happen. IHSL acknowledges and regrets the disappointment and the disruption that the delayed opening to the hospital would have caused to patients and to the board staff too. Following the Cabinet Secretary's decision to delay opening the new hospital, IHSL focused its efforts, along with the board, to agree the terms of the relevant change notice and to conclude the terms of Supplementary Agreement 2, or SA2. After a phased opening, the hospital became fully operational in March 2021. All of the evidence before the inquiry indicates that the enhancement works set out in SA2 were adequate and effective. No witness has expressed any concerns about safety of any key building system at the hospital. Despite all of the challenges and the delayed opening, the hospital is an excellent centre for the treatment of children and young people from Edinburgh and beyond. The parties worked together through all those major challenges to deliver the hospital. It is now an example of a successful NPD project in its service delivery phase. It is a facility that the board and IHSL can now be proud of. Nevertheless, it's important that the problems that led to the delayed opening are addressed by the inquiry by fulfilling the terms of reference. The inquiry can then make recommendations to ensure that any past mistakes are not repeated in future complex healthcare infrastructure projects. Turning now to the 4 main points highlighting the principal material facts that are controversial. Number 1, the interpretation of the terms of the procurement documents. The board's and Mott MacDonald's view is that the procurement documents were clear that the environmental matrix was not intended to be mandatory, or that it was to act as the board's brief. Mott MacDonald even invites your lordship to make findings of fact to that effect, and that's at pages 332 and 333 of the closing submission bundle, paragraphs 258 and 260.
Sorry, just give me a moment on that. Are you referring me to Council's closing statement?
Mott MacDonald's closing written statement, sorry, my lord, and the closing
Mott
submission
MacDonald.
bundle. Yeah. And that's
Could you give me the numbers again?
Yes, it's pages 332 and 333 of the closing submission bundle.
Sorry, 3.2.
332 and 333.
Yes.
So Mott MacDonald do, however, accept that the procurement documentation contains some potential ambiguities and inconsistencies. The interpretation of the procurement documents is controversial. As your Lordship has said, it is not for the inquiry to determine the correct interpretation of the procurement documents or the contractual provisions in the project agreement. But there are two key provisions in the procurement documents which neither the board nor Mott MacDonald refer to in any significant way in their analysis.
Right. Can I just take the opportunity, which I was going to take in any event, Mr. Gillespie? You say that it's not for the inquiry to interpret what is the proper construction of the tender documents, and I take it that your position would be the same in relation to the project agreement.
Yes, my lord.
Therefore, when I'm reporting, I won't be doing that.
Yeah.
So could you just steer me to say what I should do when I'm reporting?
So I suppose what I'm addressing here is the request from one of the co-participants for you to find, in fact, that the procurement documents were clear in a certain interpretation.
I see, right.
And what I'm saying is that, yes, my lord, that it's not for the inquiry to rule on an interpretation, but there might well be findings of fact that the inquiry make in that background. But this is a sort of challenge to the request made by one of the co-participants for you to find, in fact, that their interpretation of the procurement documents is clear and correct. And the point I'll go on to explain to my lord is that I think in terms of counsel to the inquiry's closing submissions from the previous hearing, the conclusion was that the terms of the procurement documents were ambiguous and unclear. And our position, my lord, is that given the parties hold firmly opposing views on the interpretation of the procurement documents, that is a fair assessment. Right. That the terms must have been ambiguous and unclear if they're open to two very firmly opposing interpretations.
Right. So you're essentially agreeing with counsel's assessment. Yes. Now, I interrupted you. You were about to draw my attention to two provisions.
Yes, my lord. There's two key provisions that seem to be absent from the analysis carried out by Mott MacDonald and NHS and the board in relation to the procurement documents. The first is found in section 2.5.3 of volume 1 of the bid documents. Mott MacDonald has told the inquiry...
Paragraph 2.5.3 of
volume 1.
Of volume 1.
Of the bid documents, yes, my lord. Mott MacDonald has told the inquiry that volume 1 was a document which explained the procurement process to the bidders. They explain it became redundant at financial close, and that description is contained in paragraph 39 of Mott MacDonald's closing statement at page 223 of the closing submission bundle. The board explained to the bidders in section 2.5.3 of volume 1 that its specific room requirements, defined as the room information, were detailed in a combination of documents which included the board's construction requirements and the environmental matrix. The specific room requirements set out what the board wanted and what it expected bidders to provide. In other words, it's brief. The inquiry has heard that as late as August 2012, it was the board's and Mott MacDonald's intention that the environmental matrix would set out specific parameters that bidders were required to meet. The inquiry has not seen any documentary evidence, as far as IHSL is aware, recording any change to that intention.
One might ask, what was the relevance of the intention?
I think the inquiry was told by one of the Mott MacDonald witnesses that the intention had changed from making the environmental matrix a mandatory document to one that wasn't. And the documents that the inquiry had seen were internal documents that hadn't been released to bidders at the time. So the bidders were unaware of that, but it's the background point, I think, is that the board and Mott MacDonald's position or intention had changed between August 2012, when that internal paper was prepared, and the beginning of 2013, when the bid documents were issued to the bidders. I think fundamentally the point is, if there was a change of intention, that was not clearly set out in the bid documents to the bidders.
But equally, the original intention had not been signalled to bidders.
No, my lord. But section 2.5.3 of volume 1 said to bidders, these set out the board's room requirements. And there's a further point. The bidders were also instructed by section 2.5.3 of volume 1 to develop room data sheets, incorporating the room information, which included the environmental matrix. And this involved tailoring the generic room data sheets to suit the board's specific requirements for the project. The second provision is the definition of the environmental matrix in volume 1. This was defined as the environmental matrix issued as part of the board's construction requirements in volume 3 of the bid documents. Volume 3, in turn, described the environmental matrix as detailing the board's room environmental condition requirements within each department, unit, space, and area. Even if one accepts that volume 3 was only future-facing, pointing towards the project agreement which would ultimately be executed with the successful bidder, the bidders were being told that the environmental matrix would form part of the board's construction requirements, or the BCRs, which the successful party would be obliged to meet once the project agreement was signed. It is IHSL's view that any interpretation of the procurement documents which does not take section 2.5.3 of volume 1 as its starting point, and indeed centre point, or worse, ignores it altogether, is partial and incomplete. Such a one-sided view of the procurement documents does not assist the inquiry. The board and Mott MacDonald appear to have arrived at their clear meaning of the procurement documents by disregarding those key provisions. Given the parties' firmly held opposing views, the most that can be said is that the terms of the procurement documents were ambiguous and unclear. They were not clear in the sense contended for by the board and Mott MacDonald, and they do not support the findings of fact that Mott MacDonald invites the chair to make.
I'll go back to the detail, but my recollection is one point that the Mott MacDonald written statement, the closing statement, is that they say of counsel to the inquiry's analysis that it's based on a misunderstanding or an ignoring of the different functions of volume 1 as against volume 3 of the procurement documentation. I appreciate this is very broad, Mr. Gillespie, but as I understand it, and as I say, this is not a detailed argument, that you've got to bear in mind that Volume 1 is instructions to bidders as to how they have to go about the procurement process, whereas Volume 3 is at least the first draft of the board's construction requirements. Now, the reason I draw that to your attention is what you've just submitted to me, that an understanding of, and we're looking at the procurement documents at this stage, an understanding of these documents depends on taking into account 2.5.3.
Yes, my lord. I think you're correct, my lord, that the Mott MacDonald submission is that the Volume 1 and Volume 3 serve different purposes.
Yes.
Volume 1 being the instructions to bidders, Volume 3 being this idea of a future-facing volume that would appear in the project agreement. We've addressed that point in a closing submission following the hearing of last year. And I think our view is that you can't wholly ignore Volume 3 for the purpose of the procurement process. That cannot be a correct interpretation, but even if one accepts that, and Volume 3 was only future-facing, it was still communicating to bidders that the environmental matrix would form part of the board's construction requirements once you come to sign the project agreement, if you are successful in the bid. Main point number 2, the interpretation of the project agreement. The interpretation of the project agreement provisions is controversial in a number of respects. IHSL wishes to highlight 4 specific issues. The first relates to the status of the environmental matrix. The disputed status and content of the environmental matrix was followed through into the terms of the project agreement. The relationship between the environmental matrix and the BCRs is disputed. IHSL's position is that the bid documents had consistently pointed towards the environmental matrix as forming part of the BCRs in the project agreement. The BCRs in the project agreement required compliance with the environmental matrix and defined the matrix as setting out the board's room environmental condition requirements. The board, on the other hand, considers the environmental matrix as forming part of Project Co's proposals. However, the environmental matrix was identified as being reviewable design data, or RDD. It was found in the project agreement alongside the room data sheets in Schedule 6, Part 6. The environmental matrix was not contained in Project Co's proposals. Those were found in Schedule 6, Part 4.
Mr. Gillespie, bear in mind this is quite a detailed submission you're giving at reading speed. So perhaps bear that in mind on pace. Now, what I've got is the board's position, and then you went on to, I've noted this as the environmental matrix as part of the board's construction requirements. Have I noted what you've just said correctly?
So the board's position is that the matrix formed part of Project Co's proposals.
Right, yes. Yes.
Yeah, so the matrix was not contained in Project Co's proposals. Those were found in Schedule 6, Part 4. The matrix was actually found in Schedule 6, Part 6 of that schedule. So it's sat as a sort of hybrid position. It was in neither Project Co's proposals or the board's construction requirements. It was found in a separate part of the schedule. And the point I was about to make, my lord, was that the board has no basis for saying, which it does at paragraph 66 of its closing statement, And that's closing submission bundle, page 180.
Well, just give me this again. You're referring to the board's recent closing statement.
Yes, my lord.
Could you just give me the paragraph?
So it was paragraph 66 of the closing statement. And that's closing submission bundle, page 180.
Yes.
And it's, I think the statement I'm referring to there is their statement that they were correct in viewing the matrix as forming part of Project Co's proposals. But my point here, my lord, is that the board has no basis for saying that. They were correct in viewing the environmental matrix as forming part of the Project Co's proposals because it wasn't located in the relevant part that contained the Project Co's proposals. It sat outside of the Schedule 6, Part 4, which contained the Project Co's proposals. There's also no basis for the board to state that responsibility and risk for any errors in the environmental matrix lay with IHSL, or that this was a fundamental aspect of the risk allocation provisions of the project agreement. If that is the board's position, the project agreement simply does not bear this out. The status of the environmental matrix as RDD led to ambiguity because it became subject to the board's approval. The extent to which the environmental matrix became subject to the board's approval through the RDD process is also controversial. Had the RDD process been limited to the 7 outstanding points at financial close, it would have made sense to include the matrix as RDD to that limited extent. But the board thought that the environmental matrix was subject to review in its entirety, and that approach caused problems on the project. The second issue concerns the notion that compliance with SHTM 0301 was mandatory. This is promoted by Mott MacDonald in their closing statement, and they invite the chair to make a finding in fact to this effect. And that's found in paragraph 257 of their closing statement. Page 332 of the closing submission bundle.
232.
Paragraph 257,
yes,
and page 332 of the closing submission bundle, my lord. This notion appears to stem from the board's and Mott MacDonald's view that the project agreement somehow gave primacy to the SHTM guidance. The project agreement and the BCRs did not give primacy to the SHTMs. In fact, the project agreement gave primacy to the board's particular requirements set out in the BCRs. Clause 5.2.4 of the project agreement, which has its genesis in SFT's standard form of NPD project agreement, specifically said so. Paragraph 2.3 of the BCRs said the same thing. The terms of the project agreement do not support a view that primacy was given to the SHTM guidance, or that compliance with SHTM 0301 was mandatory.
Yes.
I was anticipating a question, my lord.
No.
That's it. Thank you. The third issue concerns compliance with guidance and what that looks like. Both the board and Mott MacDonald have.
This is the yes. This is the third of your. No, it's not.
So this is main point number 2, which is the interpretation of the project agreement.
Yes, you're still on point. Yes.
This is point 3 of 4, my lord.
Yeah.
Yes, so the issue of compliance with guidance and what that looks like. Both the board and Mott MacDonald have erred in treating the guidance as providing hard and fast rules that can act as a project specification. Indeed, the board has stated that its brief was the obligation in the BCRs to comply with the guidance. Counsel to the inquiry has already addressed the problems of making compliance with the guidance a contract obligation in the closing statements following both of the hearings. On this point, however, IHSL wishes to highlight the closing statement made by National Services Scotland, or NSS. At paragraph 2 of that statement, and that's page 358 of the closing submission bundle, NSS notes the multiple references in Counsel to the Inquiry's closing statement to SHTM 0301 and SHFN 30. NSS states as follows, and this is a quote from their written closing statement, my lord. Whilst these are important documents to consider, NSS would emphasise that all applicable guidance should be considered holistically when briefing, designing and constructing facilities. This reduces the risk of an over-reliance on or incorrect application of a single piece of guidance. Guidance should always be implemented by appropriately competent and experienced individuals. And that's the end of the quote.
So what does that mean?
So, I was about to say, my lord, I think given the reasons for the delayed opening of the hospital in July 2019, it's understandable that so much focus has been placed on SHTM 0301. However, NSS helpfully reminds us that the guidance must be properly approached and handled correctly, because it has to be reviewed holistically and considered all in the round without taking individual pieces out of context. Or
well, can I ask the question in a slightly different way? I mean, that's a sort of statement that sounds excellent, but where does it take us? As you rightly say, concentration has been on a particular part, essentially one line in a table to SHTM 0301. Now, even that line is not entirely uncontroversial, but there is a majority in favour of the proposition that it requires 10 air changes an hour and 10 pascals of positive pressure. Now, where does NSS's observations about the importance of holistic interpretation take us?
I think the context of the point, my lord, was more in relation to the board's position that their brief was just this obligation to comply with guidance. Mm-hmm. And I think in that context, NSS comments are helpful. They clarify that I think something more in terms of direction is needed than just simply allowing parties to try and comply with the guidance, because the guidance it needs to be considered holistically and in the whole, and that doesn't give you.
So do you read this as a general point that the SHTMs are unsuitable as a source of a contract specification?
I think the point IHSL, I think, would make, my lord, is that if there are specific parts that require to be complied with and are to be treated as a project-specific brief, then those parts ought to be highlighted.
Right. Just give me a moment to note that.
And this is the fourth point, my lord, in relation to the interpretation of the project agreement. And this fourth point concerns the meaning of design risk passing to IHSL. The board and Mott MacDonald emphasised the passing of design risk as being a feature of the NPD model, but that does not mean all risk. The board and Mott MacDonald both failed to acknowledge that IHSL and its supply chain hold the design risk for complying with the board's specific requirements for the project. IHSL's obligation was to ensure that its design met the BCRs. With a clear brief, IHSL takes the risk of meeting that brief, but the board retains responsibility and the risk for those requirements. IHSL refers to the closing statement from Scottish Futures Trust. And that's closing submission bundle pages 364 to 365.
That's the page numbers.
The page numbers, yes, my lord. Yes. And that statement very helpfully comments on the passing of design risk in the context of the NPD model project agreement provisions. And that's particularly paragraph 5 of that statement. And linked to this is the concept of operational functionality. The board is only responsible for matters of operational functionality when it reviews the project co's proposals. However, the board is wholly responsible for its own requirements set out in the BCRs. The concept of taking responsibility only for operational functionality becomes nonsensical when commenting on a document which was said to represent the board's specific room requirements.
Right, let me just take that more slowly. The board is responsible for its construction requirements.
Yes, my lord.
Now, can I understand your nonsensical point?
Yes, my lord. So it's that sort of interface of design risk and responsibility. And when the board are reviewing and approving project co's proposals through the RDD process, they only comment and take responsibility for matters of operational functionality. But that breaks down when we're talking about a document like the matrix, which essentially set out what IHSL considered were the board's specific room requirements.
Again, so that I understand your point, Mr. Gillespie, are you saying that once, well, I'm not sure if this is what you're saying, are you saying that once the board strays into comment on, for example, the detail in the environmental matrix, it has gone beyond functional, operational functionality? Is that the point you're making or not?
I think that is part of the point I'm making, I think, my lord, but I think probably primarily the point is that the matrix, given that set out the board's specific room requirements in IHSL's view, it shouldn't have been part of the RDD process at all, except to that limited extent of the 7 outstanding points at financial close. Main point number 3, my lord, is the issue of the financial pressures on IHSL when SA1 was executed in February 2019. Given the structure of the NPD model and the unusual length of the delay to the completion of the project, it was inevitable that there would be financial pressures on IHSL. It is, after all, a special purpose vehicle. However, the risk of IHSL's insolvency and the part that such a risk played when the board entered into SA1 is controversial. IHSL has addressed this point more fully in its recent closing statement, but wishes to highlight 4 short points here. First, the risk of IHSL entering into insolvency was not one that the Scottish Government considered to be a likely outcome. Mr. Morrison explained to the inquiry that when he was considering the board's business case for SA1, he did not consider this to be a realistic risk. Had it been a real risk, it would have been escalated up to the Cabinet Secretary, but it was not. Second, it could be said that there would have been a risk of insolvency if SA1 had not been executed and had neither IHSL nor the senior lenders taken any preventative measures. The likelihood of neither party taking measures to prevent an insolvency would have been remote, but that requires unnecessary retrospective speculation. Third, the reality was that SA1 was the parties' agreed method of resolving their disputes to avoid court proceedings in March 2018. IHSL did not foresee at that time that it would take a further year to execute SA1, a year in which the board presumably thought the financial pressures were mounting.
Can I ask you maybe just to tease that point out? The dispute in early 2018, summons drafted, as I understand it, essentially resolved by about the end of March. Not in a signed agreement, but in what I'm thinking of as a more informal agreement.
Correct, my lord. I think, yes, in terms of the multi-bed ventilation issue, yeah, the agreed resolution to that issue had been achieved by the end of March 2018.
Right, and you make the point that IHSL might have expected an executed agreement earlier than February 2019.
Yes, my lord, that was the expectation of that.
Right, now how does this fit in with financial pressure?
Well, I think, my lord, the time it took to get from that agreement in principle to then executing the SA1 in 2019 was just shy of a year. So if financial pressure and the alleviation of those pressures was a driver or the key driver for the board to enter into the agreement, one might expect that to have happened at some point earlier than February 2019.
Right. Okay. Sorry. Yes, I think I'm with you now. So you're saying if the board really were that concerned, they would have executed the agreement, which would have released, if I'm understanding correctly, presumably the first payments in respect to.
Or, my lord, I think there were other steps that could have been taken, falling shy of a full settlement agreement like SA1. I think other proposals had been put forward by IHSL through the course of 2018 that might have allowed, for example, the multi-bed ventilation room dispute and the monies relating to that to be released earlier because the works had been completed by Multiplex at their own risk through that period of 2018. So there were other steps that could have been taken potentially to resolve other matters or an earlier stage. I think that the point made on IHSL's behalf is that the board entered into SA1 in February 2019 when it was ready and willing to do so. And the fourth point, my lord, is that it should be borne in mind that IHSL also made a significant financial contribution to the settlement, as well as the Scottish Government through the auspices of the board.
And was that payment made in February 2019 or had been paid beforehand?
I think that was part of the SC1 process, a sort of injection of further sub-debt.
And that happened in February 2019?
I think that's correct, my lord. It certainly was part of the terms of the SC1, yes. So the context, I suppose, of this point, my lord, is the board has described SC1 as a bailout of the project, and indeed the board has said paragraph 20.5 of the closing statement, closing submission bundle, page 164, that it had no real choice except to bail out IHSL. But that was not a view shared by the Scottish Government or IHSL. Had the board truly considered SC1 to be a bailout at the time, or had it been the board's primary intention to avert the threat of insolvency, the board would have taken or could have taken earlier opportunities to alleviate any financial pressures, but they did not do so. Main point number 4, my lord, the letter from IHSL dated 31st of January 2019. IHSL has addressed the letter in its recent closing statement. The interpretation of the terms of the letter and the reliance placed on it by the board are controversial. The letter requires to be considered in its proper context. That context was described in Ms. Freeman's witness statement. Ms. Freeman sought assurance on inspection and maintenance regimes across the NHS estate in Scotland in light of issues with pigeon droppings at the Queen Elizabeth Hospital in Glasgow. IHSL's letter to the board, which reflected the letter from Multiplex to IHSL, was issued in the context of inspection and maintenance. It allowed the board to respond to the Scottish Government's request for assurance on those particular matters. The letter also requires to be viewed in terms of the factual timeline. The board approved the terms of SC1 on the 6th of February 2019, but then the board issued a further letter to IHSL 6 days later on 12th of February. That letter specifically sought assurance on design and installation matters. IHSL's response to that letter was still outstanding when the board and IHSL executed SC1 on the 22nd of February. The further letter of 12th February requesting assurance on design and installation issues indicates that little or no assurance was taken by the board on those specific matters from the earlier letter of 31st January, which was issued in the context of maintenance and installation. That's the 4 main points, my lord. Mm-hmm. I'll turn now to your lordship's recent note of matters.
Thank you. Yes.
There are 12 matters identified in the note. IHSL cannot address them all and makes no comments on matters 7, 8, 10, 11, and 12 in the note. But IHSL would briefly summarise its position on the remaining matters as follows. In point 1 of the note, Your Lordship addresses Council to the inquiry's suggestion that the Chair may wish to consider whether some independent advice should have been sought on the technical resolutions in SA1. IHSL understands that the basis of the suggestion by Council is whether some independent advice should have been sought by the Board before it signed SA1. If so, IHSL is unable to comment on what requirement there may have been for the Board to obtain independent technical advice. That said, the evidence heard at the recent hearing was that the Board staff had between them the requisite knowledge of the guidance, the Board's clinical requirements for ventilation, and the function of the clinical spaces. The Board also had a lead technical advisor. If the Board had the benefit of technical advice, then that advice, combined with the knowledge of each of the relevant Board personnel, suggests that there was sufficient expertise available and no independent technical audit was required. In point 2 of the note, Your Lordship invited comments on the question of whether items 4, 7 and 13 of the technical schedule to SA1 triggered an obligation to complete stage 2 of the high scribe process again. The premise of this point appears to be that the Board considered items 4, 7 and 13 to be changes in the design of the ventilation system. However, IHSL's understanding of the Board's position is that the agreed resolutions in the technical schedule represented a clarification of the requirements by way of an agreed resolution, not changes to it.
Yeah, no. So the premise is unsound.
Yes, my lord. I think that's the case. There was a wider question, I think, in point 2 of the note as well, but unfortunately, IHSL can't comment on that application of the stage 2 high scribe process. In point 3, Your Lordship invited comments from core participants on whether it was incumbent upon the Board to instruct an independent validation of the specialised ventilation systems. IHSL understands that the Board's position was that it always intended to procure independent validation prior to patient occupation, and it was incumbent on them to do so.
Sorry, I just missed Mr. Gillespie.
So it's IHSL's understanding that the Board's position was that it always intended to procure independent validation prior to patient occupation, and it was incumbent on them to do so. So I think that point's addressed by the Board in their closing statement, paragraph 56.
Right.
And that's closing submission bundle at page 176.
Okay, if you just maybe give me that again.
So the reference is paragraph 56 of the Board's closing statement. It's closing submission bundle at page 176. I think at that paragraph, the Board explains that they had always intended to carry out independent validation of the systems.
Right. Just give me a moment to see so I can have the. Sorry, Mr. Gillespie.
Sorry.
Just wonder if you're referring to which page?
So it was page 176
176.
of the closing submission bundle. I think that should be paragraph 56 of the board statement.
Yes. Right. So, am I right in just quickly reading the NHS Lothian's paragraph? Am I right in reading that as a reference to the HScribe requirement?
I think that's right. Yeah, I think it is in the context of the
Right.
HScribe.
Is that validation?
Validation.
Or do you equate that with validation?
I think the question in point 3 of your lordship's note referred to independent validation and whether it was incumbent upon the board to carry
I mean,
that
the
out.
question refers to the SHTM 0301 rather than the HScribe procedure.
Yes, all I'm saying, my lord, I think is that the points addressed by the board themselves in their closing statement.
Right.
I think, as I understand the board statement, they say that they had always planned on carrying out that validation process prior to patent occupation.
I think I've read it differently. I thought what the board was saying, the two things may be the same thing, but the board as the relevant authority has an obligation to carry out the HScribe, a procedure which is comes from SHFN 30. Now, Chapter 8 of the SHTM 0301 talks about commissioning and validation. Now, it may be that carrying out the requirements of HScribe comes to be validation, but it didn't appear to me that that was obvious. I take the point that Lothian said we're always going to do HScribe, but it was too early to have done so in, for example, February 2019. What I was quite interested in, and this may be entirely wrong, Mr. Gillespie, is that whether or not Chapter 8 of SHTM 0301 imposed an additional obligation to achieve validation of the project. And within that, there would be the question as to whether, if you have a contract which provides for an independent tester, whether the work of the independent tester is to be equated with validation. The other question being as to whether the independent tester under an NPD contract is in fact an independent tester.
Yes. Potentially string into matters that are kind of coming out with the remit and the expertise of IHSL, potentially, my lord, on this. But certainly on the point of the independent tester, that would not be our understanding, that would be a function of the independent tester's role to carry out independent validation. The independent tester being a contractual appointment between the board and Project Co to administer and fulfill the contractual appointment services. That wouldn't be, as we understand it, a job for the independent tester. So it would require an external sort of provider to come in and do that independent validation.
Right. So I appreciate it. It may be that this is not a matter you've given consideration to, but you're offering an answer that, if I've understood, that the independent tester under the NPD arrangements is not necessarily, or maybe not at all, an independent tester or an independent source of advice on validation.
I think that's probably right, my lord. Right. They wouldn't be the party carrying out an independent validation of mechanical systems. Mm-hmm. That wouldn't be the independent tester's role.
Yes.
In point 4, IHSL does understand that the Lochran's Award was designed and built to meet the environmental room conditions in the environmental matrix of 31st of October 2014. And those parameters did not reflect the summary guidance in Table A1 for neutropenic wards. Point 5 of the note, perhaps be broken into two parts. First, your Lordship invites core participants to comment on the board's contention that had it not been for Mr. McKechnie's interpretation of the relevant guidance, the inconsistency between the specification, critical care, contained in the matrix and the terms of SHTM 0301 would have been identified earlier. Mr. Kechnie's interpretation of the guidance is addressed elsewhere in the closing statement from Wallace Whittle. His interpretation was only one factor that might have led to the inconsistency between the specification and the guidance not being picked up earlier. As the inquiry has heard, there were many missed opportunities. Had Mr. McKechnie held a different view of the guidance, it would be speculation now whether the inconsistency would have been picked up any earlier, particularly where the matrix was understood by the designer to be the client brief. The second part of point 5 is Mott MacDonald's proposition that any lack of a finalised document clearly setting out the technical requirements for ventilation at financial close had no causal connection to the delay in the opening of the hospital. Given the relevant legal landscape, it stands to reason that Mott MacDonald would argue that proposition, given its involvement in preparing the bid documents and technical schedules of the project agreement. It is not a credible position, however. Had there been a clear and unambiguous brief setting out the parameters that the board actually wanted the ventilation system to achieve, the issues that caused the hospital not to open as planned would have been avoided. There would have been no room for differing interpretations of guidance on output parameters, because the board was best placed to identify the essential output parameters for the particular clinical uses it had in mind. Point 6 can also be broken down into two parts. The first part refers to the board's argument that any ambiguities in the BCRs or derogations from guidance should have been brought to the board's attention, and that flagging non-compliance was a contractual obligation on IHSL under the project agreement. IHSL has addressed the relevant contractual provisions in the project agreement in its response to PPP 10. IHSL simply wishes to highlight here that the board's view on the obligations under the project agreement is misguided. Clause 12 of the project agreement obliges IHSL to carry out the works so as to procure satisfaction of the BCRs. There was no obligation on IHSL to challenge or highlight ambiguities in those BCRs. It's interesting to note from paragraph 25 of the board's closing statement, and that's closing submission bundle, page 165.
Sorry, again, Mr. Gillespie, if you're referring me to
paragraph 25 of the board's closing statement. And that's closing submission bundle, page 165.
165, thank you.
That the only contract provision that the board identifies to support its position is paragraph 2.3, subparagraph K of the BCRs. This obliged IHSL to take account of guidance in the Scottish Health Facilities notes, such as SHFN 30, subject to what was expressly contained in the BCRs. The board says that Part B of SHFN 30, which describes the high scribe process, sets out responsibilities on various entities, including those of the lead contractor. This, they say, includes an obligation of coordinating and advising the infection prevention and control team to assist in identifying potential risks and control measures prior to and during construction. The parties will have different interpretations of this provision, but the provision does seem to concern the assistance to be given by the lead contractor to the IPC team in identifying potential risks. It provides no basis for saying that IHSL was contractually obliged to highlight any non-compliance with guidance to the board. The second part of point 6 asks whether IHSL, Multiplex and Wallace Whittle should have in place their own processes for design review and audit. IHSL appointed Multiplex as its design and build contractor. Multiplex in turn appointed Wallace Whittle as its M&E subconsultant designer. It would be inappropriate for IHSL as the special purpose vehicle to engage a separate independent review or audit of its supply chain's design. IHSL is not a designer. It does not have design expertise, and it would have been unrealistic and inappropriate for IHSL to have in place internal processes for design review and audit. As for the board's comment that Mr. McKechnie was a single point of failure, given the many missed opportunities to identify the inconsistency between the specification and the guidance, that comment strikes IHSL as being inaccurate and unhelpful. And finally, my lord, on point 9, IHSL agrees with the potential recommendations made by Council to the inquiry that your lordship could make in an interim report. That concludes my remarks.
Thank you very much, Mr. Gillespie. I appreciate that I've rather taken you over your estimated time. Thank you.
Thank you, my lord.
No, I think it's probably your turn, Mr. Barne, on behalf of Lothian Health Board. In previous sittings of the inquiry, we've taken a coffee break at about 11:30. I'll just put myself in your hands and feel free to indicate a break whenever you see it makes best sense.
Thank you, my lord. On behalf of NHS Lothian, I'd like to thank the chair for this opportunity to make closing submissions. My lord, I intend to take this at reading speed until your lordship wishes to investigate. A hard copy of my submissions can be made available if that would help.
Well, let's think about this. I entirely understand why legal representatives have written out what they propose to say. I mean, my impression was that was what Mr. Gillespie had done. And of course, it's just my job to keep up with you as best I can. In using the term reading speed, perhaps you might bear in mind my writing speed. It had been my ambition, Mr. Barne, that this would be an opportunity for your main points and the things which you think I particularly would benefit from assistance on. I mean, I do have the previous written statements.
Yes.
Mr. Barne.
Thank you. Detailed and extensive written submissions have already been provided during the course of the inquiry on behalf of NHS Lothian, and I adopt those. I will therefore restrict myself to making 5 brief general remarks before addressing the 12 specific issues that have been raised by the Chair. I shall then briefly address Bundle 13, which was recently provided by the inquiry and relates to research into ventilation. Turning to my introductory remarks, my first is about patient safety. Throughout the project and beyond, NHS Lothian has prioritised patient safety above all else. All decisions taken by the board and NHS Lothian personnel were made in good faith and with the best of intentions. There has been no evidence that the board or the project team made any decisions in the knowledge that they might compromise patient safety in any way. There was also no evidence that any decision made by NHS Lothian was made in order to save face. From the board's perspective, the project proved to be extremely difficult. Even so, the project team proactively engaged throughout with the aim of delivering state-of-the-art facilities. To the extent that it might be suggested that the project team became too involved, that can be explained by the fact that the project team was acutely aware of the duty of care that NHS Lothian ultimately owes to its patients. Perhaps one of the overriding lessons that can be learned from what occurred with the new hospital is that all parties to this type of complex construction contract should acknowledge and operate under a duty of candour to ensure that patient safety is paramount. Any derogation from guidance should be identified and captured by the contracting parties in a manner that ensures that all parties understand, firstly, the nature and scope of the derogation, and secondly, the reason for the derogation. This approach should also apply to any ambiguities or potential derogations that may or may not be contained in the employer's requirements.
Sorry, just give me that again.
Suggesting that
your general point includes
not just actual derogations, but ambiguities or potential derogations that may or may not be contained in the employer's requirements.
Right, so when you're talking about an actual derogation, presumably a derogation that is registered under the derogation procedure.
Yes.
Right.
But I'm also intending to expand the point to capture ambiguities or inconsistencies in contractual documentation that may have implications for compliance with guidance and therefore potentially have implications for patient safety. My second general remark is to acknowledge that there were missed opportunities to catch the error that ultimately led to the hospital not opening in July 2019. On behalf of NHS Lothian, I acknowledge and apologise for its role in what can only be described as the collective failure to identify the error. My third introductory remark seeks to address the reasons why the error was not identified before July 2019. These are both straightforward and complex. The fact of the matter is that the contractor's ventilation designer, Stuart McKechnie, considered the ventilation rates as installed in critical care complied with guidance. The causal potency of Mr. McKechnie's error is best demonstrated by the fact that he chose to amend Guidance Note 15 of the Environmental Matrix, which specified the correct ventilation rates for critical care, without drawing that amendment to the attention of NHS Lothian or, so far as I'm aware, to anyone else. This was the only such change to the environmental matrix which was not highlighted in red. Had the change been flagged up, the error could and probably would have been discovered in November 2015. What is less straightforward to understand is why no one on the contractor's side challenged Mr. McKechnie's approach. This is not something that has been explained, so far as I'm aware, in the evidence. It is also not obvious why those on NHS Lothian's project team, and primarily their technical advisors, did not identify the error. The evidence tends to suggest that those on the project team reviewed documents narrowly from the perspective of their own particular disciplines, which may have meant that the dots were not joined, as one of the NHS Lothian witnesses suggested. Ultimately, though, the inquiry is invited to bear in mind that NHS Lothian was not responsible for the design of the new hospital. It was a matter entirely for IHSL and Multiplex. And in that context, it becomes clearer why members of NHS Lothian and its project team did not identify what was, after all, a design error.
Can I interrupt up to it? Sorry, can I interrupt you at this point, Mr. Barne? I think throughout the inquiry, the error which we're talking about, which is the air change rate and the pressure difference, I think people have talked about it as a design, a feature of the design, and therefore, if it's not achieved, that's a design error. Is it a matter, I mean, design to me suggests choice, how you go about doing something, and would include, presumably, the positioning dimensions of ducts and fans and things like that. Is a specified output an aspect of design?
In this context, I would suggest it is.
Right.
Because everything that is not operational functionality, so far as
Right, okay.
the risk provisions in the project agreement, falls within the scope of design, I would say.
All right, okay. So for present purposes.
Yes. Now, I do acknowledge that certainly Mr. Gillespie, for instance, would say that compliance with the board construction requirements is an aspect of design that ultimately falls onto the client. But that takes us back into an argument which I shall address briefly in due course. My Lord, turning then to my fourth introductory remark, this relates to the issue of whether or not the reference design environmental matrix was a fixed brief. IHSL and Multiplex argue that it was, and that they built the hospital to its terms. Much ink has been spilt in arguing about the contractual status of the environmental matrix, both when it was only a reference design document and at the stage that it was formally adopted and adapted by Wallace Whittle on behalf of the contractor. I shall not revisit those arguments here. Instead, I would suggest that in the context of this inquiry, such arguments are of secondary importance. Large infrastructure projects will always involve a huge number of documents. Ambiguities and inconsistencies are inevitable. The issue is how are such ambiguities and inconsistencies to be resolved in a way that protects patients' safety? I would suggest that there was, at the time, and there still is, an obligation on a contractor to flag up any actual or potential derogations from guidance in a client's brief, whether or not they are or appear to be intentional. Now, in terms of that obligation, I would say it's both a contractual obligation, and that is set out in our closing statement. But I would also say there's a broader obligation, and that is one to which, as I'll come on to allude, Mr. McKechnie recognised.
And the broader obligation is, if you had to analyse it, contractual or something else?
Well, in this case, I characterise it as a patent ambiguity, and certainly a designer faced with a patent ambiguity is required to flag the issue. But over and above that, an issue that may have implications for patient safety is one that should be addressed as part of the partnership working to which counsel to the inquiry referred to regularly in his questions to witnesses. This is a point that Mr. McKechnie himself accepted by saying that where a client's brief appears to derogate from guidance, this should be specifically raised and checked with the client. Of course, the reason that this did not happen here is that Mr. McKechnie considered the cells in the environmental matrix complied with SHTM 0301, and he chose unilaterally to amend Guidance Note 15 to remove the patent inconsistency that existed. Viewed in this way, and from the perspective of patient safety, the issue of the status of the environmental matrix, be it fixed brief or otherwise, is subsumed into the broader question: why did the contractor, who is required to design the new hospital, fail to identify and clarify the patent inconsistency in the environmental matrix?
And this is the internal inconsistency, the difference between the guidance note and the cells of the spreadsheet.
Yes, and in our written submissions that have preceded today, we make the point regularly that if one looks at the contractual documentation, the obligation to comply with SHTM 0301 is all pervasive. It's referred to on numerous occasions as set out in the earlier closing statement. Now, I take the point that there's an argument that the terms of the environmental matrix somehow is an express derogation from guidance. That is not an argument I wish to explore today, as this is a matter addressed in our first closing statement.
Right. No, I asked the question just to, you've introduced the concept of patent ambiguity.
Yes.
And I'm just wondering whether that was confined to if you were just looking at the environmental matrix, or whether you're including in what you say a designer should do in relation to patent ambiguity, as to whether you include an inconsistency with another document, in this case, SHTM 0301.
Well, When I refer to patent ambiguity, I'm talking about the internal inconsistency.
The internal inconsistency.
But I would also make the wider point that faced with a design that is in conflict with an important piece of guidance, and where that guidance is given a high degree of prominence in the board's construction requirements, then that again is an aspect of the ambiguity that I would submit requires to be explored by the designer. My final general remark is that I wish to emphasize that NHS Lothian has already learned lessons. It has implemented an enhanced assurance framework for new capital projects in parallel with NHS Scotland Assures development of key stage reviews. I refer to Susan Goldsmith's evidence at the most recent hearing, and this can be found at transcript pages 126 to 128, and to John Conahan's evidence at transcript pages 160 to 162.
Sorry, I should know the name. John?
Conahan.
Do we, does the inquiry have the documentary statement of that from NHS Lothian?
By documentary statement?
I mean, is there, well, when you began to introduce me to the already implementing, what I gathered from what you were saying, there was some protocol or something or other.
The assurance framework, yes. I think it's the assurance framework, and that has been produced.
In the bundles for the evidential hearings or since?
If I may, I'll get that reference
right.
in due
Thank you.
course. I don't have that to hand.
Thank you.
Having said that, of course, NHS Lothian look forward to reviewing the inquiry's findings and recommendations with a view to making further improvements to its processes. I suppose I would say it's a journey and not a destination. My Lord, those are my general remarks. I'm now going to turn to the specific issues that have been raised, and that might be a convenient time for a coffee.
Well, we'll break until 11:45. Mr. Barne.
Thank you, my lord. In relation to that reference that I didn't have for your lordship at the end of matters just before the coffee break, I understand that all the materials showing sort of the lessons learned theme can be found in Bundle 13, Volume 11. And I made particular reference to the assurance framework, and that can be found, I understand, at page 4.
Page 4. Thank you. Yeah.
I'm turning now to the specific issues that have been raised by your lordship. The first issue focuses on whether it was necessary, proportionate, or appropriate for NHS Lothian or the Scottish Government to have instructed a technical audit of the technical solutions set out in Settlement Agreement 1. The board's response to this issue is that it would not have been, and I shall expand on that response. At the outset, it can be observed that the phrase technical audit is not itself a technical term,
No.
nor is it a term of art. It is not a term that is used in any of the standard forms of construction contract, be they traditional or design and build. A simple internet search throws up various possibilities as to what a technical audit might comprise, but these are all context dependent. The importance of participants in a complex construction project having clearly defined roles is a theme that has pervaded the evidence to the inquiry. It therefore strikes me that discussing the merits of a technical audit without knowing precisely what is meant may tend to confound matters further.
I mean, I take the point. I mean, if you use an expression which is not a term of art or is not readily understandable, begs the question as to what on earth you're talking about. I think I'm right in saying that counsel to the inquiry may have introduced the notion of technical audit. If I'm wrong about that, I apologise to him. Okay, I take the point about precision, but you're about to make more observations having made that, right?
Yes, that really was very much an introductory comment.
Yeah, okay.
I go on to say, even so, it would be important to locate a technical audit within the contractual framework that existed under the project agreement. In that regard, what appears to be agreed by all core participants is that under the NPD style of contract, there was no need for NHS Lothian to have employed a shadow design team, and indeed they did not. This is because the risk transfer provisions that are the very heart of the project agreement do not envisage any sort of shadow design team. It should also be noted that where the board initiates any changes, and I use that term contractually, capital C changes, in terms of Schedule Part 16 of the project agreement, the risk profile of the project agreement is unaffected. In other words, Project Co still bears the risk in relation to any design associated with the board change. This goes to emphasize that design rests solely with Project Co. Turning then to Settlement Agreement 1, the inquiry is aware that this drew together into a single document the agreed solutions for a large number of disputes that had arisen during the construction phase of the project. The purpose of Settlement Agreement 1 was to fix the overall commercial terms in order to avoid the need for litigation. The solutions set out in the technical schedule had already been designed, reviewed, and built out. It is therefore unclear what purpose an independent technical audit undertaken shortly before the signing of Settlement Agreement 1 would have achieved.
On a matter of detail, my understanding is that as far as the ventilation system, or at least as far as the ventilation system of critical care is concerned, that work had been completed at least by the end of October 2018. Am I right about that?
That is my understanding.
Yeah, right.
Just pausing there, my lord, in terms of the comments that were made this morning about the delay between March 2018 and February 2019, there were a number of issues that were ongoing. Your Lordship will be aware the technical schedule contained, I think, 81 items, and it was a condition of the settlement agreement that effectively the independent tester signed off on it by way of practical completion. And that is the context in which there was an apparent, explains the time that passed from March 2018 through to October 2018 when the ventilation works were completed, and then on to practical completion in February 2019.
Did you mention something about the independent tester? I think I may just have missed that.
It was part of Settlement Agreement 1 that Arcadis, the independent tester, effectively signed off practical completion as part of the overall context.
I'm being slow on this. Part of the settlement agreement was that Arcadis would sign off once.
So my understanding is that Settlement Agreement 1 was conditional on Arcadis providing the practical completion certificate.
Well, presumably, sorry, I am being slow on this now, Mr. Barne, because let me put this back to you. The Arcadis, I don't know if I'm quite understanding this. Arcadis was the independent tester under the NPD contract, which predated Settlement Agreement 1. Am to understand what you're saying as that it was agreed that Arcadis would certify practical completion on the basis that the works identified in the technical schedule had been completed. Is that the point, or am I missing it still?
My recollection is that Settlement Agreement held over certain works which didn't form part of what required to be part of practical completion. Okay. So in terms of the rest of the works, as varied by Settlement Agreement, it was necessary as a condition of entering into practical Settlement Agreement 1 that Arcadis had certified practical completion on that revised basis.
Notwithstanding that there were still works to be done.
Yes.
Right. Sorry. My apologies for being slow.
Not at all, my lord. If the purpose of the proposed technical audit would be to ensure that a suggested design solution is reviewed prior to implementation, then the timing, nature, and scope of such a review would need to be defined before its efficacy in any particular case could be assessed. But what is clear is that, for reasons already discussed, any such review would not comprise a full design review. IHSL was the designer, and the design risk transferred to IHSL under the project agreement, except in relation to operational functionality. NHS Lothian also questions the practicality of having an additional tier of professional input, which would require to be consulted during the construction phase. There would be a need for there to be clarity as to the circumstances which would trigger the need for an independent technical audit. And I make the observation that presumably it wouldn't arise in relation to each and every potential change under the contract. A requirement for a technical audit would also increase the potential for delay, the cost of which would be borne by the client. And the contractual consequences of the independent review would be entirely unclear. For instance, if the independent reviewer challenged aspects of the design and those challenges were not accepted by the designers, what then should happen? Standing the terms of the project agreement, NHS Lothian had no locus to raise objections to issues of design except in relation to operational functionality. Finally, in the context of the project itself, it should be recalled that NHS Lothian received advice on technical solutions from its technical advisors, Mott MacDonald. This, it is submitted, was an entirely appropriate way for the board to proceed. Indeed, it has not been suggested by anyone that the board did not include within the project team a suitable group of professional advisors. For these various reasons, NHS Lothian submits that it would not have been appropriate, practical, or proportionate to have an independent technical audit of proposed solutions undertaken either before the solutions were implemented or before Settlement Agreement 1 was signed.
Just, right, either at the two dates you have in mind, March 2018.
Well, I was talking more generally, but in terms of ventilation, yes, that would be March 2018. Turning then to issue 2, which is whether or not changes that arise during the construction phase should be subject to a stage 2 high-scribe assessment. In considering this question, it is important to bear in mind that high-scribe is an operational tool rather than a document with which to check compliance. high-scribe is intended only to explore infection risk. It does this by identifying a hazard, identifying the risk of acquiring infection from that hazard, and then removing or mitigating the hazard to minimize the risk of acquiring infection. high-scribe cannot therefore be relied on to detect all possible clinical and non-clinical risks from a design or construction perspective. It is focused only on exploring factors or hazards in a healthcare building setting that may predispose patients or staff to acquiring an infection. high-scribe stage 2 is about design and planning intention for the project as a whole, rather than individual spaces or infrastructure elements. This means that at stage 2, everything is still hypothetical, the aim being to identify hypothetical hazards from collective, multidisciplinary experience. Such experience is gained from other projects and buildings, as highlighted in contemporary guidance or unpublished peer experience.
Mr. Barne, just on the question of pace, did I understand that you were prepared to share your speaking note with me after at some later date?
Indeed, my lord.
Right. The reason I asked that question is that if you're expecting me to take a note at this speed, I can't do it. But if I'm going to see the full text at a later stage, carry on at the speed you consider appropriate.
It does strike me, my lord, that there are certain issues that the inquiry has raised that requires quite a lot of detailed input from those whom I'm representing. And I had to try and strike a balance between what we put into the responses and what may be available afterwards, as I'll come on to discuss.
Yep.
But I can be slower if that's of assistance. But
no, I don't necessarily need it now. I just need the assurance that, I mean, for example, you've detailed the practical difficulties with my technical audit idea. Now, I would like to have available to me at some stage a list just to make sure that I've noted everything you have to say.
I will make sure that those notes are available.
Okay.
So I was making the point that stage 2 is about a hypothetical assessment. And I was saying that in the terms of the project itself, the assumption was that there would be compliance with guidance. So it is unlikely that anybody would have flagged a hypothetical issue that nobody considered at the time was an issue. Stage 3 high-scribe is about construction, when things are actually being built. So it is primarily about making sure the construction works do not interfere with and compromise the clinical environment elsewhere if there is active clinical space nearby. Stage 4 high-scribe assesses the building's performance based on how it has been built and checks that the systems and spaces perform as anticipated against requirements. Where the building is found not to be performing as anticipated, stage 4 aims to ensure that operational mitigations against any infection risk are in place. So in terms of the particular issue raised by your lordship, returning to stage 2 mid-construction would be unusual. The high scribe process is intended to have a linear progression from stage 1 to 2, 2 to 3, and then 3 to 4. Once construction has commenced, the high scribe assessment process is already considered to be at stage 3. It is important to note that at stage 2 and stage 4, the questions to be considered are essentially the same. So undertaking a stage 2 high scribe during construction would be like trying to undertake a stage 4 high scribe in a partially built environment, but without having the commissioning data available to test compliance. Such an assessment of clinical infection risk is more informed and fruitful once the installation is complete and running, i.e. at stage 4, rather than trying to anticipate during construction how it might eventually work. It is therefore NHS Lothian's position that there would have been little point in undertaking a stage 2 high scribe in 2018 because the design parameters which were developed from the clinical output specification remained the same for the project as a whole. The ventilation systems were already installed and construction was at an advanced stage. It was thought by NHS Lothian that the ventilation system was compliant with guidance other than known derogations, and high scribe is not a tool with which to check compliance with guidance. It is NHS Lothian's submission that the starting point for all parties in a contract must be compliance with guidance. Where any party wishes to propose either a design change or derogation, a clear process should be followed with input from all stakeholders, which identifies the following: what the relevant guidance requires, the nature of the design change or derogation that is being agreed to, and the reasons for that design change or derogation. The assessment will include a formalized process involving, as a minimum, IPC, authorizing engineers, and clinicians to explore whether the design change or derogation can be accepted as appropriate in terms of patient and staff safety. The high scribes can then be completed with reference to any agreed design changes or derogations in place at the time. Any necessary design changes or derogations which arise during construction and post-date high scribe stage 2 will have been reviewed by all relevant stakeholders, including IPC, by virtue of the design change or derogation process itself. The construction phase design changes and derogations can then be taken into account in high scribe stage 4. My Lord, I turn to issue 3, which is the appointment of the independent tester. And by that, I mean that the issue is whether the terms of SHTM 0301 effectively obliged NHS Lothian to appoint an independent tester to validate the ventilation system. In NHS Lothian's submission, the answer is yes, and this is what occurred via the instruction of IOM. I will address this issue first under reference to the 2014 version of SHTM 0301, which was the version in place during the project. I explain later with reference to issue 8 the importance of the changes made to the authorizing engineer's role in the current SHTM 0301, being the 2022 version. SHTM 0301 makes a distinction between commissioning and validation. In summary, commissioning can be undertaken by the specialist installer, and individual items of equipment can be commissioned in isolation. However, as the 2014 version of SHTM 0301 explains, and this is a quotation, validation differs from commissioning in that its purpose is to look at the complete installation from air intake to extract discharge and assess its fitness for purpose as a whole. This involves examining the fabric of the building being served by the system and inspecting the ventilation equipment fitted, as well as measuring the actual ventilation performance. The project agreement covers commissioning both by Project Co and the board in clauses 17 and 19. Project Co was...
Just give me that again. Clauses 17 and 19 do what?
This covers commissioning by both. There are different aspects of commissioning, some undertaken by the Project Co and some undertaken by the board. Clause 17 covers commissioning by the Project Co and Clause 19 covers commissioning by the board. Project Co was responsible for commissioning elements built and installed by them, which included commissioning the ventilation system. The board's commissioning elements related to the installation of NHS Lothian equipment and was dependent on works in areas to be complete before board commissioning could commence. In relation to validation, this did not form part of Arcadis' appointment and was not governed by the terms of the project agreement. Responsibility for validation sat with NHS Lothian. NHS Lothian instructed IOM as a suitably qualified independent party to carry out the validation of the ventilation systems when the building was ready for patient occupation. This was in compliance with the requirements of SHTM 0301.
Right. Can I interrupt with apologies? I think you've been quite clear that Chapter 8 does impose an obligation on health authorities to, presumably at the completion point, but prior to occupation of a facility, to carry out validation by an independent engineer. Now, maybe a slightly unfair question, but is that what was the original intention of NHS Lothian, let's say in January of 2019?
My understanding is that was the intention.
Sorry.
My understanding was it was always the intention to undertake a validation. There was a confusion with one of the, as expressed by one of the NHSL Lothian witnesses, as to whether or not the commissioning data could be used for purposes of a high scribe assessment.
Yeah,
which is a slightly different point.
My recollection, I'm thinking of Mr. Henderson. If I'm right in my recollection of the evidence, Dr. McBrearty was engaged or wishing to engage in the high scribe stage 4, January, February of 2019. One of the questions that he would have to, or whoever would, or the team that addressed the question set in stage 4 would have had to apply their minds to is whether the building complied with SHTM 0301. Now, Dr. McBrearty, as I recollect his evidence, was not satisfied with the documentation he had. Now, I have to say, I assumed it was in relation to that question and probably other questions. And there was a interaction with Mr. Henderson. Mr. Henderson was not presenting any difficulties, but in a context where, again, as I understood it, Multiplex were not producing documentation to the satisfaction of Dr. McBrearty, Mr. Henderson said, we'll get an independent or a authorised engineer. But what I took from that evidence was that Mr. Henderson was producing an ad hoc solution to Dr. Inveraty's issue, which was that he did not have the documentation available for HighScribe stage 4. I didn't pick up from Mr. Henderson that he had always planned to instruct either IOM or some other authorised engineer to validate in compliance with Chapter 8 of SHTM 0301.
My recollection of the evidence is that aligns with what your lordship has indicated, and there was some question raised by Mr. Henderson's evidence by him, and I think it showed perhaps a lack of clarity that in a context where the hospital is technically owned by IHSL, I think Mr. Henderson was not clear in his own mind which party was required to undertake validation. But it is clear, as hopefully my submission makes out, that NHS Lothian accepts that validation was a matter for them to undertake. The interactions between Mr. Henderson and Dr. Inveraty involved whether or not the commissioning data that was available was in a form and sufficient to satisfy Dr. Inveraty. I think Dr. Inveraty's position was that it wasn't because it didn't effectively engage with the criteria for SHTM 0301.
Well, again, we can look at the evidence. I thought Dr. Inveraty was talking about the HScribe process.
That's my understanding. Yes.
Right. Again, I apologize for being slow. So I'm a right or am I not right to have got the impression that Mr. Henderson had not intended to instruct an independent engineer to carry out a Chapter 8 SHTM validation process. Am I wrong in that?
Unfortunately, we don't have Mr. Curry's evidence, but so far as Mr. Henderson was concerned, I think as at January 2019 and thereafter, my understanding of Mr. Henderson's evidence was that he was just not clear whose responsibility it was.
Thank you.
When the issue of the validation arose, NHS Lothian initially approached their usual authorising engineers to undertake the validation testing, but they were unavailable. NHS Lothian then sought advice and recommendations from HFS for other suitable organisations. HFS referred NHS Lothian onto the British Services Research and Information Association. This association then referred the issue to Malcolm Thomas, who is a key author of SHTM 0301, and he suggested the instruction of IOM as a suitable alternative provider of the authorising engineer services. NHS Lothian proceeded to instruct IOM as the authorising engineer for the validation of ventilation in the new facilities. Given that validation did not form part of Arcadis' appointment, it is as well at this point just to clarify Arcadis' role as independent tester. This is discussed in more detail at section 5 of NHS Lothian's response to P6. The scope of Arcadis' services can be found at Schedule Part 13 of the project agreement. The scope of the services to be provided by Arcadis was broad and included the following. Clause 1.2, undertaking regular inspections of the works and to report on the completion status of the project, identifying any work that is not in compliance with the BCRs, the PCPs, the approved RDD and/or completion criteria. These are all contractual terms. Clause 1.8, monitoring the works against the required standards of construction quality and reviewable design data. And clause 1.9, monitoring the works for compliance with the BCRs, PCPs, and compliance with the law. And I would make the observation that having regard to the nature and scope of their duties, NHS Lothian relied on and took assurance from the practical completion certificate issued by Arcadis to the extent that the ventilation system installed was compliant with guidance, subject to the agreed derogations.
They relied on Arcadis because they understood that in order for Arcadis to approve work, Arcadis's task was to approve work as as having been completed in terms of the contract. And NHS Lothian assumed that assumed is the wrong word. We're proceeding on the basis that in fact, all SHTMs were compliance with all SHTMs was contractually required.
Subject to the agreed derogations.
Subject to the derogation.
Well, turning to issue 4, which concerns Lochranza. It is accepted that in terms of Appendix 1 to SHTM 0301 2014, the entry for a neutropenic patient ward applies to Lochranza. In NHS Lothian's view, Appendix 1 applied to the treatment areas within Lochranza, but not to other areas such as the nurses' station or corridors.
And the treatment areas would include the bedrooms. All the bedrooms.
It's my understanding.
Mm-hmm.
It is also accepted that some of the cells in the environmental matrix of 31st of October 2014 for Department C1.4, that's Lochranza, were incorrect. NHS Lothian therefore accepts that these cells departed from guidance. Finally, it is accepted that IHSL and Multiplex designed and constructed the ventilation system for Lochranza to the incorrect values in the reference design environmental matrix of 31st October 2014. The error was dealt with by way of project code change number 50 and was addressed operationally. Issue 5 concerns Mr. McKechnie's interpretation of SHTM 0301. I have addressed this issue to some extent in my general remarks. NHS Lothian's position is that the proximate cause of the delay in the opening of the hospital was Mr. McKechnie's unique interpretation of the relevant provisions of SHTM 0301. Mr. McKechnie accepted in his evidence that whatever the client brief, he would have flagged up any departures from guidance. This was clearly his obligation, especially in light of the obvious inconsistency that was apparent in the reference design environmental matrix. And we've discussed that inconsistency, and that's between guidance note 15 and the individual cells for critical care. The fact that Mr. McKechnie did not flag up the inconsistency was because he did not think there was any departure from SHTM 0301. Mr. McKechnie's interpretation is the golden thread that runs from the environmental matrix adopted by Wallace-Whittle before financial close to the discovery by IOM of the inadequate ventilation rates in critical care. As I have already observed, there will always be uncertainties or ambiguities in a client brief for large construction projects. That is why designers should scrutinize the board construction requirements to tease out any such ambiguities. It was not the client brief that caused the problem, it was the failure of IHSL and its subcontractors to flag up what was an obvious ambiguity in the reference design environmental matrix. It will also be recalled that Multiplex imposed a design freeze during the preferred bidder stage. This included not completing a full set of room data sheets. That is why so much design was put into the reviewable design data process. But even if design had been completed pre-financial close, given Mr. McKechnie's interpretation of SHTM 0301, it is unlikely that the issue would have been flagged up. Issue 6 concerns NHS Lothian's contentions. These relate to the suggestion that there is an obligation on a contractor to raise actual potential derogations from guidance with the client to ensure that they are intended and understood. In this regard, I'd refer to NHS Lothian's response to PPP4, which identifies a number of contractual obligations regarding compliance with guidance. NHS Lothian would like to take this opportunity to make the broader point that, particularly in a healthcare context, the relationship between client and contractor should be one of partnership working, a concept that counsel to the inquiry regularly referred to. Parties should approach any ambiguities in construction documentation with the overriding objective of ensuring patient safety. I would also point out, in this case, the project agreement expressly addressed the possibility of ambiguity. Clause 5 of the project agreement obliges Project Co to procure that the defined term project operations are at all times performed in accordance with various specified standards, and in the event of any ambiguity, Clause 5.2 establishes an order of precedence in terms of those standards. This is mirrored in the board's construction requirements, which establishes at paragraph 2.5 a hierarchy of standards in the event that there is any conflict or ambiguity in the contractual documentation. Issue 7 relates to Mott MacDonald's role and whether or not it was properly understood. On this issue, I would observe that the evidence of Brian Curry would have been extremely important, given that he was closely involved with Mott MacDonald throughout. But it's my submission that NHS Lothian knew and understood that Mott MacDonald were not providing a shadow design function. They were providing technical input, including technical assurance in relation to various disputes that arose and which were captured in the technical schedule to Settlement Agreement 1. In her oral evidence, Susan Goldsmith explained her understanding that Mott MacDonald were providing assurance to the board to the effect that what IHSL were delivering was a hospital that would meet the board's construction requirements. While she accepted that may mean that Mott MacDonald were required to consider design on some occasions, she understood that that was not their main function. This accords with Contract Control Order of 26th of February 2015, which required Mott MacDonald to, and quoting here, continue to be part of an integrated delivery team with NHSL and to undertake a wide range of management, advisory and supporting tasks, both from a project management and technical advisory perspective. One of the specified duties in the Contract Control Order that was incumbent on Mott MacDonald was to, and quote here, monitor the construction of the works with respect to compliance with the building contract. So I should read that again. Monitor the construction of the works with respect to compliance with the building contract. The phrase compliance with the building contract would encompass, in my submission, compliance with the board's construction requirements. NHS Lothian understood that providing assurance in relation to compliance with the board's construction requirements and providing design assurance are two different things. There has been no evidence in my submission to suggest that this distinction was not understood. But what the query is invited to have close regard to is the fact that throughout the project, both NHS Lothian and Mott MacDonald repeatedly reminded IHSL and Multiplex that it was for IHSL and Multiplex to construct the hospital in accordance with the board's construction requirements and not in accordance with the reference design. Issue 8 concerns the updated SHTM 0301. I've been provided with some detailed comments on this by Dr. McBrearty and the capital project team at NHS Lothian. These can be provided to the inquiry if that would be of assistance. Just by way of example, Dr. McBrearty comments on the ambiguous use of hyphens in Appendix 2, given a hyphen might be interpreted as no value given, negative, or as part of a range of values. Indeed, I understand that such ambiguities have actually already caused some problems.
So you're promising me Dr. McBrearty's commentary?
If that would be of assistance.
I can only imagine it would be.
I didn't think it would be helpful simply to read out everything that he'd written because it was a bit...
Yeah, I mean, I can't take it in at that speed.
Of course not. Although the terminology around critical care in the latest version of SHTM 0301 is clearer with reference to level 2 and level 3 than the earlier version of the guidance, there are still nebulous and ambiguous terms that are used in the table, such as neutropenic patient ward and general treatment room. It was my understanding that these terms are perhaps not as
clear. At the
clear.
same time, you say a proper construction of 2014 version of neutropenic patients would have included all treatment areas in Department C1.
Yes. In relation to the question of whether the revised guidance would have made a difference on the project, it is to be hoped that the revised wording in relation to critical care would have meant that an outlier interpretation of the requirements, such as that displayed by Mr. McKechnie, would not arise. However, compliance with SHTM 0301 will still require designers to identify what does and does not meet its terms. Accordingly, compliance with the revised SHTM 0301 will still be perilled on designers taking a sensible and realistic approach to its interpretation. The updated version of SHTM 0301 provides for a greater role for authorizing engineers. During the project and in terms of the 2014 guidance, authorizing engineers had an ad hoc role and were not usually involved in commissioning. However, the 2022 version, which was authored by several authorising engineers for ventilation, is explicit that the authorising engineer for ventilation should be involved in reviewing the construction of ventilation systems at several points in time before they are covered up by ceilings and walls. This would include reviewing the commissioning data, even though their role will be as the independent validator after commissioning is over. In summary, NHS Lothian broadly agrees that the revisions in SHTM 0301 are addressing issues that arose at the new hospitals, making it less likely that they will be repeated. In particular, NHS Lothian welcomes the increased role for authorising engineers and the role of the ventilation safety group. Issue 9 relates to recommendations, and I don't wish to add to the written submissions that have been provided. Issue 10 relates to NHS Scotland Assure. As detailed in its written closing submission, NHS Lothian notes the establishment of NHS Scotland Assure and observes its progress with interest. As recommended by Council to the inquiry, NHS Lothian agrees that the role of NHS Scotland Assure should be part of a wider review of governance, guidance and procedures. However, the current KSAR process is very resource intensive and could be streamlined. In addition, it is suggested that in order to add value, NHS Scotland Assure requires to do more than provide a check that health boards are following appropriate procedures. Issue 11 concerns the authorising engineer. NHS Lothian has been asked to confirm whether NHS Lothian instructed an authorising engineer in respect of the project prior to the instruction of IOM. The answer to this is yes. An authorising engineer is appointed to act as an auditor for NHS Lothian across its entire estate and across various disciplines, e.g. fire, electrical, ventilation, water, and medical gases. The authorising engineer recommends competent authorised persons for each discipline. There was no formal role for authorising engineers on the project in terms of the project agreement, but it was part of the authorising engineer's wider role across the NHS Lothian estate to provide ad hoc advice as and when required.
I'm sorry, entirely my fault. I'm not sure if I'm following that. The reason I asked that question was that I think Mott MacDonald draw attention to the evidence that indicated that in addition to all the other advisors that Lothian had, they had consulted an authorising engineer. Now, as I understood it, the source of that was Dr. McBrearty's evidence, and it appeared to me that that passage in his evidence indicated that he was speaking as a matter of what he would expect to happen, not entirely clear in what context. Now, as I understand it, authorising engineer is a term of art, and I'm not quite, it's certainly used in SHTM 04. I don't know if we find authorising engineer in SHTM 0301.
My recollection is referred to, and the suggestion is that it's unlikely for validation purposes that the authorised engineer would have the sufficient expertise.
But anyway, you've given an answer in terms of sort of general advice over the Lothian estate. I
was wishing to...
Was specific advice asked or received in relation to this project?
I was providing the context to the fact that the authorising engineer did not have a role in terms of the project agreement. So returning to my submission, if I may, the authorising engineer in this project did provide ad hoc advice, for example, in 2016, in relation to the resilience of the IHSL proposed ventilation strategy for isolation rooms. There were ongoing meetings between IHSL, Multiplex, Wallace Whittle, and Mott MacDonald to discuss the proposed ventilation strategy, at which both the authorising engineer and IPC were present. So in answer to your Lordship's question, the authorising engineer was present as part of a wider remit across the entirety of the NHS.
Right. So Mott MacDonald, if I'm remembering Mott MacDonald's written statement correctly, Mott MacDonald are right.
Yes.
Right.
Sorry, perhaps I should have just said that.
Right. Thank you.
Issue 12 and 4 relates to the NSS report, and I have no submission on that. The final part of my submission briefly addresses the NHS Scotland Assure position on research, which forms, I understand, volume 13 of bundle 13. And that's a paper that was produced dated the 13th of June, 2024. In preparing a brief response to that paper, I have been assisted with some preliminary remarks provided by Dr. McBrearty. The overall approach of NHS Scotland Assure to research into the built environment seems to be to act as a conduit to provide funding opportunities to principal investigators in other academic institutions, rather than initiate and perform the research themselves. This appears different to the approach taken by UK Health Security Agency, where there are long-established research groups conducting their own research portfolios into the healthcare built environment, such as the Biosafety, Air, Water and Microbiology group at Porton Down. The model that NHS Scotland Assure seem to follow with regards to producing guidance is to commission scientific literature reviews about aspects of infection control and the built environment, of which there are many currently in progress, but so far little of this has been progressed to fully operational guidance. The process relies heavily on the goodwill of Health Board IPCT members reviewing revisions of multiple documents. It is resource intensive for the Health Board infection control teams to participate. This is particularly so when IPC teams are experiencing diminishing staff numbers and trying to deliver their IPCT duties to their own health boards. Finally, Dr. McBrearty notes the inclusion in the bundle of DL 2024-11. He notes that this document is contentious in the infection control community in Scotland. I understand that concerns were raised with its content at the pre-publication stage, and there are inconsistencies with other guidance, but it was issued without these being satisfactorily resolved. I'm also told that it is unpopular amongst senior IPCNs, IPCDs, and IPCMs in Scotland, who are disappointed that it was issued before resolving the concerns that were being expressed. However, none of these points should detract from NHS Lothian's willingness to engage with NHS Scotland Assure to achieve positive outcomes. My Lord, that's the end of my submission, and I acknowledge I've undertaken to provide two documents. First, a transcript, effectively, of my submission, and secondly, Dr. McBrearty's comments.
Well, I find that very helpful. Thank you very much indeed, Mr. Vaughan. Now, Mr. McBrearty, on behalf of Mott MacDonald, if it's convenient for you to begin.
Good afternoon, my lord. I, of course, adopt the written closing submissions for Mott MacDonald in full. Your lordship, I think, should also have had this morning a written response that was prepared in response to your lordship's particular queries.
Yes, I do.
The intention was to simply cut down on the time that's required of me and to allow, I think, me to focus on more general points.
Yeah.
However, if your lordship does wish to hear from me specifically on any of the points raised in that paper, I'm, of course, happy to address it.
I will reread it. I have read it, and I'm working on the basis that you've said what you consider needs to be said.
Yes. Okay. Thank you, my lord. If I might then just emphasise those points in the generality that I wish to, and if I might start, my lord, just by making two general observations about the role played by Mott MacDonald. The first is one which is just a very general point. As your lordship is aware, Mott MacDonald's role was, of course, twofold. They were technical advisors, they were also project managers. And I think it's fair to say that what the inquiry has had the opportunity to look at here has simply touched on a sliver of the work that was undertaken by Mott MacDonald, because they had involvement in almost all aspects of the project, not just ventilation, of course, but architecture, electrical work, facilities management, civil and structural matters, acoustics, energy modelling, fire prevention, flood prevention, and even assisting with the provision of the helipad, and project management of all aspects of those matters. And as technical advisors, they were there in a hands-on role, sharing the same space and working collaboratively with NHS Lothian, who were, of course, an informed and experienced client. And I say all of this, my lord, not to be defensive about Mott MacDonald's role. It's simply the fact that they hold the belief that, looked at overall, they added genuine value to this project as a whole for the benefit of the client. And I think it's reasonable to bear in mind the breadth and the quality of the work that they did beyond simply the small area which this inquiry understandably has been looking at. The second general observation I might make, my lord, is simply about a possible misunderstanding about Mott MacDonald's role when it comes to matters of design and technical assistance. And I just wish to make clear what Mott MacDonald's position is. As your lordship will have gathered, of course, from the written submissions, Mott MacDonald's position is that they were not employed to provide design assurance, and they maintain that position. Looking to other core participant submissions, it appears that this may have been picked up on in certain quarters as suggesting on Mott MacDonald's part that they were not providing any kind of design or technical advice or assistance. And I just wish to make clear that that's not Mott MacDonald's position. They were providing technical advice in relation to matters of design, and there's no inconsistency between providing that kind of advice on the one hand, and on the other hand, not providing design assurance. There's two quite different things. There's an important distinction between technical advice on the one hand and design assurance on the other hand. And just to take, if I may, a very simple example, I'm not suggesting it's one that necessarily occurred, but to take a simple example, my lord, if it happened to be the case that on a particular occasion, NHS Lothian were to have come to Mott MacDonald and to say to them, could you please tell us what the appropriate ventilation rate or pressure was for a particular room of a particular type, then of course, as technical advisors, having regard to the guidance, then one would expect that Mott MacDonald would have been in a position to provide that technical advice. However, once the party responsible for the design produces that design, it was not Mott MacDonald's task to give assurance over that design. It was not their task to check it line by line and to give the assurance that it conformed to the relevant guidance. And as I understand it, given what said by NHS Lothian and what was said by Mr. Barne today, it seems to be that Mott MacDonald and NHS Lothian are at one in their understanding as to what Mott MacDonald's role was. There appears that between those parties there was no lack of clarity in relation to Mott MacDonald's role. And those responsibilities that Mott MacDonald had in my submission should be seen, of course, in the context of this having been an NPD contract. And in that context, it was not for Mott MacDonald as technical advisor to provide design assurance. They were not there to be a shadow design team, because even leaving aside the contractual arrangements and the understanding between NHS Lothian and Mott MacDonald, for them to have provided shadow design work would, in effect, have undermined the whole basis of the NPD contract. The whole purpose, understandably, is to place design responsibility onto the private sector, and therefore for the private sector to be responsible for giving the appropriate assurances. It would, in effect, have cut across the whole risk profile of the contract, and would, indeed, in doing that, also have involved considerable extra cost to the public purse, and would have prolonged the project programme. Because, as I understand what's said by counsel to the inquiry, it would, in effect, have required a full technical audit on the part of those assisting NHS Lothian. For Mott MacDonald, I don't make any judgment, my lord, on the choice of contract. It's a matter for the parties to the contract to make a commercial judgment as to the nature of the risk that they're each prepared to take on, and therefore, on the back of that, to choose the form of the contract that they're prepared to enter into. But once parties choose the NPD contract, the risk profile in my submission is clear. Now, having made those general observations, my lord, if I might, trying to get to the heart of what I say are some of the really important matters here, if I might make clear two general matters that Mott MacDonald accept, but equally in doing so, make clear what is not accepted in relation to each of those matters. And if I might make them in short form to begin with, and then come back to expand upon them a little. The first, my lord, is that I accept, of course, that there is room for argument as to the proper interpretation of both the tender documentation and the contract documentation itself. And of course, particularly I mean in relation to the status of the environmental matrix, whether it was a fixed brief or a matter within the responsibility of those designing the project. From the written submissions that your lordship has received, your lordship will have seen that Mott MacDonald contend that objectively read, the wording of the tender and contract documents was unambiguous, and the matrix was a matter for those designing to deal with. Others in their written submission say that the wording unambiguously shows that the environmental matrix was to be read as a fixed brief. I think, having had the benefit of reading all of those submissions, my lord, what I can say is that where different parties say that the wording is unambiguous, each in different directions, I think the only thing that we can be clear of is that there was ambiguity to that extent.
And at the risk of being unduly superficial, that's a thought that has occurred to me. I mean, for example, in your closing statement, you provide a very detailed argument. And as you say, I've had the benefit of other pretty detailed arguments. But at the moment, I don't really see it's my role to do more than recognize that there are different respectable arguments.
I respectfully agree with that, my lord. I mean, it's there in our argument. We have given it to your lordship in detail because the ground was covered, and it seems right that we should give your lordship the benefit of our submissions on that. But I entirely understand the position that your lordship's in. It's not a matter for your lordship to determine the parties' civil rights and obligations in the context of this inquiry. And it's exactly why I put it in the way that I do. And it's exactly why I don't intend to labour the point here about why we say we're right in our interpretation. Your lordship is faced with competing interpretations. It's not for him to resolve that. There is ambiguity. And I recognise that. In recognising that, my lord, what I do not accept on behalf of Mott MacDonald is the suggestion that this ambiguity lay at the heart of the problems which then emerged. It would no doubt have been better had there been no ambiguity, although it could hardly be said to be a rarity in complex construction contracts that sometimes an ambiguity arises. But the essential point I make is that insofar as there was ambiguity, my lord, there was no, in effect, causal connection between that ambiguity and the problem with the ventilation which then ensued. If I put that another way round, my lord, if there had been no ambiguity, then in my submission, the problem would have arisen in any event.
And that's because of Miss McKechnie.
Precisely so. And I make clear, my lord, this is not a question of me. I don't wish it to be thought that I'm seeking some vendetta against Mr. McKechnie personally, or suggesting any. The counsel to the inquiry has noted that there can be no question of bad faith on his part, and I don't dispute that at all. But it is at the heart of the causal potency of what then ensued, and I'll come on to expand on it. But I suppose there's a broader question in any event, my lord. Mr. McKechnie is at the heart of it. But if one puts to one side the wording of the contract and the tender documentation and instead looks at the actions of the parties, and I include within that Mr. McKechnie, I'll come on to expand on this, then in my submission, it becomes clear that the environmental matrix was never really treated as a fixed brief. Because there are many actions, and I'll come on in a moment to expand upon them, but there are a number of actions which we can look at which are simply inconsistent with the suggestion that the environmental matrix was a fixed brief. Mr. McKechnie's is, I think, the best and most potent example of that, but perhaps in a moment I could come back to that. But in terms of causative potency, the review of the environmental matrix by Wallace Whittle is what lies at the heart of the ventilation issues which ensued. I'll come back to that. The second matter that Mott MacDonald accept, if one leaves aside Mr. McKechnie's review, then of course Mott MacDonald accept that there were opportunities to discover the problem in the environmental matrix. Although for my part, I think I would probably prefer to use the term occasions on which it might have been discovered. Mott MacDonald also accept that they were a party to those occasions, and they could have noticed the problem. But the emphasis that I put on, my lord, is on the word could. In my submission, we're not in the territory of should. In other words, of those occasions on which the problem might have been noticed, in relation to none of those, there were none of those occasions in relation to which Mott MacDonald plainly failed to do that which was incumbent upon them and which would have led to the problem being discovered. And if we're looking again at real, truly genuine missed opportunities, the one glaring missed opportunity again is the review of the environmental matrix by Wallace Whittle. I'll come back to expand. If I might just expand on what I say about the actions of the parties, my lord, and again, this is against the background, the point I'm essentially making here is that whatever ambiguities lay in the documentation in my submission, the conduct of the parties was inconsistent with the environmental matrix being a mandatory part of NHS Lothian's brief. And let me focus, if I may, on three general points here when I'm talking about the conduct of the parties. First, I would ask your lordship to focus on the fact that the environmental matrix was taken over by IHSL and that significant changes were made to it. Your lordship has heard the evidence that IHSL took over the environmental matrix. It's a small matter, but they rebranded it with their own logo. And thereafter, as is detailed in our submissions, multiple changes were made to it. Changes in my submission which would be inexplicable if it had truly been regarded as being a mandatory part of the brief. And most pointed of all of those changes is, of course, that which is highlighted by Mr. McKechnie's evidence. Because his evidence, at least as we see it and have detailed in the written submissions, is that Wallace Whittle's design would always have had to comply with SHTM 0301, that all parameters in the environmental matrix would have been checked by Wallace Whittle against the guidance, that they did in effect carry out a line-by-line check, and that indeed his view was that the design was compliant with SHTM 0301. And in my submission, those matters, my lord, in his evidence, they're all inconsistent with the notion that the matrix was a fixed brief that took precedence over SHTM 0301.
Point of small detail, Mr. McBrearty, I think line by line was an expression that was used on a number of occasions in the evidence. And we have been shown the environmental matrix, the main body of which is a spreadsheet. At the moment, subject to correction, when people talk about line by line, I am envisaging somebody actually going, whether they're running their finger over it or not, but looking at every single line, of which there may be, I think we had one suggestion is there may be 50,000 of them.
Yeah.
But when you use line by line, and when the evidence uses line by line, is that how I should understand it?
That's how I understand it, and I think that's how I understood Mr. McKechnie's evidence. That's the way in which I approach it. Your Lordship, of course, has his evidence and can assess exactly what he said. But leaving aside whether it was he looked at every single cell or not, of course, the most pointed and significant change was obviously the change to Guidance Note 15, because it's changing a requirement for 10-year changes per hour so that it applied to isolation cubicles only. And the point I make is the obvious one. It's a significant change. It's not merely a change to add in additional spaces or to make minor inconsequential changes, nor is it a change requested by NHS Lothian. It's a change which goes to the heart of how SHTM 0301 was interpreted and made a significant difference to the overall meaning of the environmental matrix. It was a change to the guidance note, of course, but the entries in the matrix themselves refer the reader back to the guidance notes. And insofar as there was previously a discrepancy between the individual cells on the matrix and the guidance note, that was removed as a result of Mr. McKechnie's change. It was, in my submission, highly significant. I'll come back to it in a moment, but in my submission, the point I make at the moment is that the taking over the environmental matrix and the changes made to it, including to Guidance Note 15, are simply not consistent with parties having treated the matrix as if it were a fixed brief. Because otherwise, why would the party responsible for design of ventilation be making a significant change in order, it seems, to make it align with his interpretation of the guidance? I was about to pass on to the second matter and focusing on the party's conduct, but I'm content to come back.
Take that as a break for lunch.
Yes.
Yes, is it convenient to you to actually supply it over lunch? This conversation is just confirming that with the view that everyone has the same information, we're sharing a copy of your document with the other legal representatives, and that should be available to people over the lunch break.
Thank you, Mark.
We'll sit again at 2 o'clock.